As you now know, it is discrimination to terminate an employee because of a protected ground. The protected ground does not need to be the only reason for the termination to be discriminatory. It is still discrimination if the protected ground is only part of the reason for termination. Examples of discriminatory terminations include terminating an employee related to their pregnancy, disability, request for accommodation based on a protected ground, request for medical leave based on a protected ground, harassment at work due to a protected ground, and complaint about discrimination to the Commission. You, as an employer, should think about the following. Before terminating an employee, the employer should make sure none of the reasons for doing so are based on a protected ground. A termination based on a protected ground is discrimination unless the employer can show the termination is reasonable and justifiable in the circumstances or is a BFOR. The Act does not cover terminations not based on a protected ground, even if they are unfair. Those terminations may still involve other legal issues, such as employment standards. Where a termination relates to a protected ground, the employer must be able to show they reasonably tried to accommodate the employee to the point of undue hardship. Accommodation can take many forms, such as modifying work duties or allowing a leave from work. An employer should not try to disguise a discriminatory termination as reasonable and justifiable. For example, a supervisor terminates an employee claiming there is a shortage of work. An investigation shows that the employer hired a replacement employee and the reason for the termination was actually the employee's race. This termination is discriminatory. The employee can make a human rights complaint against the employer within 1 year of the termination. Severance agreements and releases. Employers may negotiate severance agreements with employees. Sometimes severance agreements contain a release, either as a clause or a separate document. A release relieves an employer of their obligation or responsibility to an employee. Usually, a release says the employer agrees to pay a sum of money to the employee in exchange for the employee giving up their right to make a claim against or sue the employer. The Commission cannot deal with a complaint if the release is valid and prohibits the employee from making a human rights complaint. The Commission can deal with a complaint where the release is invalid. Protected grounds. Personal characteristic of individuals or groups of individuals that is protected from discrimination under human rights legislation. The protected grounds under the Alberta Human Rights Act are race, religious beliefs, color, gender, gender identity, gender expression, physical disability, mental disability, age, ancestry, place of origin, marital status, source of income, family status, and sexual orientation. Protected areas. Activities that are protected from discrimination under human rights legislation. There are 6 protected areas under the Alberta Human Rights Act. 1. Employment practices. 2. Job advertisements and applications. 3. Membership in a trade union or association. 4. Goods, services, accommodation, and facilities. 5. Tenancy. And 6. Public statements. Employee rights. An employer may not end the employment of, lay off, or discriminate against an employee for exercising their rights or complying with certain obligations under the Employment Standards Code. An employee cannot be discriminated against for making a complaint, for giving or having the potential to give evidence at any inquiry or in any proceeding or prosecution, for requesting or demanding anything to which they are entitled, for making, about to make, any statement or disclosure that may be required, for refusing unsafe work. Visit alberta.ca for this and further information.